podium, but at least have a seat at that table where that microphone is.
Threats, coercion, and I'm under duress. I'll cross.
You're under duress? How are you under duress?
Well, Your Honor, as stated in my motion, there's actually fraudulent order that was sent to me unsigned by a judge. I have lawsuits filed on all of this stuff right now, which I know that they received.
Hold on, brother, wait. I'm just asking you to have a seat at the chair with a microphone.
Oh, I understand that. I'll do it. Okay. The front check.
That's fine. Just make sure you talk to the microphone.
Absolutely.
Okay. All right, you can sit down. Okay. So I think this is your motion to dismiss, right?
Yes, I have a few in there that I've been repeatedly trying to be dismissed.
Which one do you want to start with first?
Well, the recent one I filed, the motion to reject swearing in and all that, based off the fact that, like I said, I was sent a default motion that I don't know how it even got sent out past it did, but it was never signed or anything. I was also defaulted out the fact that there was a citation that never even presented a court appearance.
Okay, hold on. You're giving me too many issues. You're talking about swearing in. You're talking about a default judgment. Just pick one issue. We're going to deal with them one at a time. So what do you want to deal with first?
Well, my main motion. Well, yeah, the default.
Okay, so was that on the civil infraction, failed to disclose the CPL?
I suppose that's what it was under, yes.
Okay, don't suppose, it's your motion, brother. Tell me what it is.
Well, it keeps getting
that's the only civil infraction.
I have numerous, I have lots of stuff.
Hold on, that's the only civil infraction I see with your name on it. So I'm just confirming that we're talking about that charge.
Yes, sure.
Okay. So do you know why the default was entered? Did you miss a deadline? Did you
I was notified. I was called by people that I know within Huron and the police chief stating that I had a missed appearance date. I never had an appearance date scheduled, but I went back looking at the citation. There was no date, and actually how fast it got issued raises real concerns to me. And then once I received the default in the order.
Hold on. Let's take one thing at a time. So you said you never got an.
Welcome back to another jaw-dropping moment from the world of Sovereign. Citizens, those self-styled legal rebels who believe a few. YouTube videos and a Google search give them more legal authority than decades of courtroom precedent. Today's star. A man who seems convinced that if he says I object enough times, the judge will just throw his case out of sheer exhaustion.
For appearance date. That means the monkey's on your back to contact us.
I will also on the bottom of the tickets, it says if you fail to contact the court within this specified amount of time. There was no specified amount of time on here. I had no idea when I was supposed to contact the court. I was dealing with trying to get my attorney.
Let me ask you this. Did you contact the court?
I was again, as I said, I had no sort of any time frame to contact the court.
Mr. Crucell, this is going to go a lot easier on everybody if you just answer the question I asked. I'm going to give you plenty of chance to give me any argument you want to give. Okay? So don't feel that you have to force your argument into every question I ask. The question was, did you contact the court?
Well, Your Honor, I would have contacted the court if I had a specified.
That's a yes or no. So I'm going to take that as a no. You didn't contact the court. So after 14 days on a civil infraction, if we don't hear from the defendant, we enter default.
It was less than that, actually, when I was defaulted, Your Honor.
Less than that from what?
From whatever this was issued. And like I said, I was contacting.
Well, once again, which I think is the same one you got, is dated February 3rd.
Correct.
Okay, so that's when it was issued, February 3rd.
Correct.
So when was the default? When did you get notice of a default?
Actually, I know I got the thing in the mail. When did I get this? This says that, I don't think it specifies a date.
Well, did you make a note when you received it?
This said I don't remember exactly.
This isn't just any judge. It's one sharp, patient, but with a very clear line that you do not want to cross to right from the jump. This defendant comes in swinging with objections like a boxer throwing wild haymakers. The problem? None of them are landing. The judge is calm, but firm. I don't care what you're objecting to isn't just sass. It's a reminder that objections aren't magic spells. They need legal grounds. Here, the judge is making it crystal clear. This is motion day, not a free-for-all debate. Every time, the defendant interrupts. He chips away at his credibility and inches closer to a contempt citation. And if you...
It also specifies right here, if you fail to appear by the date specified, and then on the bottom one, even for the other one, if you fail to answer a citation by date specified. There was no dates.
Okay.
There was no dates.
Okay. Do you have anything to add?
I do, Your Honor.
Go ahead.
Mr. Crusoe brought this up when we were in front of the Honorable Judge Martin. She did set aside the default on the civil infraction, irregardless of whether or not he showed up.
Which I object to the setting
Sir,
aside.
do not interrupt the lady. Did she interrupt you?
No.
Then don't do that. Let's be civil. Go ahead.
Thank you, Your Honor. Judge Green, Mr. Crusoe did bring it up again with the Honorable Judge Green, and she declined or denied his motion based on the fact that it was moot because the Judge Martin set it aside.
So the default's already been set aside.
Yes,
Brother, why'd you just waste 5 minutes of my life?
since March 14th, Your Honor.
Which I object to that because there's
You object to your motion being?
not to any of that.
So you want to argue about the fact that you got what you asked for?
No, what I'm saying is the fact that the due process was violated is what happened in this whole problem. When I was defaulted, due process was violated.
So what? She set it aside.
Not, listen, it was set aside to cause damages to me because of what happened with the
If you've ever seen a judge snap from patient to fed up, you know it's only a matter of time before the hammer comes. Down 3, this is a classic sovereign citizen pivot. When pressed for a direct answer, you circle back into a vague narrative about not being given notice and procedural fraud. The judge, however, is laser-focused on one question. Did you contact the court? It's a yes or no, but instead of answering, the defendant tries to smuggle in his whole defense mid-response. The judge isn't having it, and neither should we in real courtrooms. The fastest way to lose favor is to dodge simple questions. At this point, the only thing the defendant's proving is that he's willing to argue about anything except the actual facts.
Ground rules for my courtroom? Is that a yes for the
Yes, Your
record?
Honor.
Okay. I'm giving you all the time you need to talk. Don't talk over her.
Okay, I understand. I'm sorry. There's just been a lot that's been going on with this.
And I'm the first time I'm seeing it, so I'm trying to get to the bottom of it.
You're right.
All right. So we started with what motion do you want to talk about first? You said your motion to set aside the default. That was granted by Judge Martin, is what I'm hearing from the prosecutor. So that motion's done. Would you agree?
As long as my money gets returned, then I guess it's taken
At
care
some point, trust me, your money will either get applied or returned. Next motion you want to talk about.
the dismissal based off of fundamental violations of my fundamental rights and due process.
Okay, well, tell me more.
Okay.
Do you have, hold on, let me just cut to the chase. Do you have more than just the fact that you think you have a right to travel?
Yes, Your Honor. Actually,
That's denied. I'll just cut to the chase. That's denied. I don't buy into that argument. Now, you can appeal that decision to the circuit court. You understand how that works? District court decisions you can appeal.
absolutely.
Okay, hold on. I've denied that motion. We're not going to talk about that motion because I've denied it based on your argument that you have a right to.
And here's where the irony hits full force. The defendant's biggest complaint is the default judgment against him. But guess what? A previous judge already set that default aside at his request. That means he literally got what he wanted, yet somehow he's still mad. This is a great example of how sovereign citizen logic can loop back on itself. Instead of moving forward, he's now arguing over whether the court was wrong to give him the exact outcome he asked for. If this feels like mental gymnastics, that's because it is, and the judge knows it. That's why you hear that sharp, "Why did you just waste 5 minutes of my life?" Here comes the first real warning. Shot from the bench, cut her off again, and you're looking at $100 in contempt? Do it twice.
Okay, but that's got nothing to do with your lawsuit. That might be the basis of your lawsuit. So you want to talk about whether or not there was a valid reason for a
Yeah,
stop?
absolutely.
Then make the argument.
But, Your Honor, so prior to me being pulled over by this officer, I was actually in contact with several law enforcement officers that are friends, and actually two that are currently working within Huron that had confirmed I had every lawful right to be doing what I was doing. The one even pulled up to me and my wife at a gas station in town, and we had, or in Sibley and Middlebelt, right near actually where I got pulled over, and we had discussed it and talked about it and went on about our day, and this was all prior to this incident. I had two other interactions with this officer where I had specifically told him, I've already been confirmed and doing lawful, I'm well within my lawful rights. I have it documented. You need to go talk to the sergeant that I've been talking to and a couple other buddies, right? I gave him that opportunity. It was shortly after that. And I had that confirmation well prior to me even being pulled over. Okay. So then, this officer seen me leaving my house, pulling off my dead end dirt road, proceeded. Like I said, I even told him, I've already had this, I've already used this, you need to go talk to the sergeant.
Right.
Chose not to. pulled me over, walked up, just started demanding ID and everything from me, and wouldn't identify himself, none of that good stuff.
And it's a night in jail. This is what courtroom control looks like, setting boundaries early so things don't spiral. And credit to the judge here. He's not flying off the handle. He's laying out the rules like a referee before a fight. At this point, the defendant has a choice: play by the rules and argue his case properly, or ignore the warning and risk turning a bad day in court into an even worse one.
ORV on the roadway constitutes a blatant violation of his First Amendment rights and an improper attempt to regulate his constitutional rights. In his most recent motion, he does accurately cite Terry v. Ohio as controlling. This was plainly a Terry stop.
Well, hold on. His argument is there was no reason for the stop.
He does cite Terry v. Ohio in his newest motion.
Okay.
Because people submit that the investigatory stop exception in Terry v. Ohio controls the validity of the traffic stop. An officer may stop and briefly detain a person on the basis of a reasonable suspicion that criminal activity is afoot. Defendant claims that he was stopped without legal justification. Rather, the defendant was stopped for operating an ORV on the roadway in violation of MCL 324.81122 as adopted by Huron Township Ordinance. Pursuant to the United States v. Ferguson, so long as the officer has probable cause to believe that a traffic violation has occurred or was occurring, the resulting stop is not unlawful and does not violate the Fourth Amendment. On authority of state law and township ordinance, a person shall not operate an ORV which is not registered upon a public highway, street, or right of way. On the date and time of the offense, the defendant operated an ORV which was not registered, specifically an ATV on Middlebelt Road, a public highway in Huron Township. Additionally, during the course of the investigatory stop, the defendant failed to provide a valid driver's license and failed to immediately disclose that he was a valid CPL.
We've officially hit the right to travel argument, the crown jewel of sovereign citizen. Mythology. The defendant throws it out there, clearly expecting it to be a showstopper. Instead, the judge swats it away in seconds. Denied. No drawn-out debate, no dramatic back and forth. It's just a flat you can appeal to the circuit court. This is how seasoned judges handle pseudo-legal defenses. Don't engage. Don't legitimize the theory. Just move on. It's the courtroom equivalent of walking past someone yelling nonsense on the street.
All right, as you define traveling, we define it operating.
Right.
So hold on, I've already ruled on that issue. You can appeal that decision to the circuit court. We're not going to plow that field again. So now we're talking about probable cause. What I just heard was the township has an ordinance that says nobody can operate an ORV on a roadway. Would you agree that's an ordinance in the township?
Your Honor, I may agree.
Yes
with
or
that.
no? Mr.
Yes, I agree with that.
Okay, stop. If that's a valid argument or ordinance, and when I say valid, I don't mean if it's constitutional, if it's, stood the test of a challenge. I mean, if it's on the books, all right? If it's a valid ordinance and the officer sees you doing what that ordinance says you can't do, and he pulls you over, that's plenty of probable cause for the stop. So your motion to dismiss for lack of probable cause is also denied. Do you need me to clarify that ruling for your appeal reasons?
Yes, actually, because Your Honor, I object to
What
the
do
fact
you
that
not
it's calling it an
understand? Sir,
ORV.
your objections mean shit to me, okay? I don't care what your objection I make. That's why there's an appellate process. So you keep saying, I object, I object, I object. I don't care, all right? It's not helpful for today's process. My decision to deny your motion to dismiss based on lack of probable cause is because there was probable cause, because there was a clear ordinance on the books that the officer thought you were violating. That gives the officer a reason to.
We're in probable cause territory. The prosecutor lays it out plainly. Unregistered ATV on the roadway, no license shown, no CPL disclosure while carrying a firearm. That's 3 separate problems, each one independently justifying the stop. But instead of addressing any of them, the defendant tries to relitigate his operating versus traveling semantics, an argument the judge has already shut down. This is a textbook sovereign citizen tactic. Keep repeating the same points, hoping the repetition will somehow make them true. Spoiler alert, it won't. Point 8, and that's where this hearing leaves us, the judge standing firm. The motion's denied, and the trial's still ahead. If you take anything away from this case, it's that patience in the courtroom is finite, and judges have zero tolerance for procedural games. Whether you agree with the law or not, ignoring it won't make it disappear. in fact, as we saw. Here, it can dig your hole even deeper.
Already been notified 2 times prior to this that what I was doing was lawful, that what I was doing was not an ORV, which I had stated to him.
But that's,
He's witness to that as
Mr.
well.
Purcell, with
So again,
respect, that's all your opinion. Obviously, the officer had a different opinion about all those things.
well,
right?
the officer chose to retaliate against me is what happened, Your Honor. Which I have the evidence and I have witnesses going on.
Or he had a difference of opinion about whether or not you were driving an ORV.
Or just didn't understand the laws.
That
or the
could be
actual
too.
wording.
That could be too. But guess who gets to make those decisions? At trial.
Well, honestly, in the trial, I'd request a jury trial, which is guaranteed.
Well, you can't get a jury trial on the civil infraction, but you can certainly get a jury trial on the misdemeanors.
Absolutely.
Okay. Do you have anything else to be discussed today on motion day?
Well, yeah, and as far as the disclosed CPL, like I said, I have, again, stating I have the body cams and I have my own
But sir,
recording.
stop. That's going to be an issue at your formal hearing, whether or not you violated that civil infraction. Once again, I got to have evidence, right? I got to take testimony. I'm going to hear from you. I'm going to hear from the officer that wrote the ticket. And then I'm going to decide at formal hearing whether or not what you did was reasonable or not reasonable. But today's just motion day. Today's not the trial. No testimony is being taken.
Oh, I understand that.
Okay. Anything else today?
Well, I guess that's no, but like I said, again, for the record, I do object to moving forward. I do object to anything moving forward from.
What do you think? Is the judge too patient, or should he have lowered the boom earlier? If you found this case as fascinating, and at times as frustrating as we did, hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.